Uh, Rajesh, Shekhar is coming.
Yes, he came, sir. He joined.
Okay.
Yes,
Okay. So,
sir.
आप और रेखा कौन चालू कर रेखा?
Just starting, sir.
Hmm.
Good evening, esteemed colleagues, dignitaries virtually present here. I am C. Rajesh Agrawal, moderator of this webinar. On behalf of Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICI, welcomes you all to our today's webinar, Writ Remedy for Assessment. I thanks to the committee chairman, C.V. Chitre sir, for giving me this opportunity. It is my pleasure to be a moderator in webinar on Writ Remedy for Assessments being organized by this committee. In a short while, we will start this webinar. I would like to apprise you about CCLEA and NPO committee. This committee is focused to encourage chartered accountants to shape strategy, policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of our core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formations, to develop and publish technical guidance, background materials, etc., and to create awareness for professional opportunity for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Excellent work under the leadership of C.V. Chitre sir. Today, we dwell into the powerful tool of writ petition, a beacon of hope and a shield of justice in the complex world of assessments. As a chartered accountant, our role extends beyond numbers. We are defenders of fairness and champions of the rule of law. Today is the new opportunity to learn from the subject experts, grow in our profession, and achieve greatness. Let's seize it with both hands. As you are aware that great achievements begin with this decision to try. We have the talent, we drive the passion. So let's channel it, all the energy and make today extraordinary. Today, let's give our 100%. Our eminent panel will talk on writ remedy for assessments in this webinar, and we hope that the same will be useful to the members present here. I request C.V. Chitre sir to give opening remark.
Well, thank you, C. Rajesh Agarwalji, who is former chairman of Pune branch, and under whose leadership Pune branch got the award of being best branch. So thanks for coordinating this particular very important webinar.
Thank you.
We have with us eminent chartered accountant C.S. Suhas Bora, the young and firebrand lawyer Sanket Bora, and also we will be joined by Bhuvanesh, who is also a chartered accountant and practicing in our tribunal and high court. Friends, as a chartered accountant, we are supposed to protect rights of the assessees. We are not saying that, okay, the assessee should avoid the tax, but then whatever rightful tax is there, that has to be paid. That has always been the institute's viewpoint. However, whenever something wrongful activities are then wrongfully tax are received, some harassment is made, I think as a council, as a chartered accountant, we will have to provide certain remedies. And recently you must have seen, say, for example, in case of Nirmal Bang Securities, when the case was reopened, it was wrongly reopened. The reasons for reopening were not appropriately recorded, and the Honorable Bombay High Court has passed strictures on the assessing authorities and stated that the reason should have been properly recorded in appropriate words. And yet another thing where the demand of 2 crore rupees was raised, and then for subsequent year when there was refund due, that refund was adjusted in spite of 20% tax being paid, and the matter was in appeal. So there, as you are aware, that if 20% of the tax demanded is paid, then further tax cannot be recovered unless the appeal is decided. And in this case, in case of Rajasthan High Court, in case of Rajendra Kumar versus ACIT, the Honorable Rajasthan High Court has imposed penalty of 50,000 rupees on the assessee for wrongfully wrongfully withholding the return in excess of 20%. And also the High Court said that you repay the refund. In case of Mantra Industries Limited, again, the respondents were put to the High Court said, and I will just quote from High Court, respondents are put to notice, and Mr. Sharma, who is the counsel for the purpose of Income Tax Department, to circulate this order right from Revenue Secretary to everybody in the Finance Ministry, that if such orders are continued to be passed, the court will be constrained to impose substantial costs and concerned assessing on the concerned assessing officer to be recovered from his or her salary, and also direct the department to place such judicial orders in the careers record of the authority. Even when no personal hearing was given, although demanded by the assessing officer, in case of Milestone Brandon Private Limited, cost of 10,000 rupees was imposed on the assessing officer. And again, the cost of 50,000 was imposed on an assessing officer of the Income Tax Department for passing an order harassing the assessee. The assessing officer issued a provisional attachment to the bank order stating that there are dues under section order passed under section 281, and this particular order never reached the assessee. So without issuing this penalty order, when the attachment was made, I think that is inappropriate. And then the cost of 50,000 rupees was imposed. Now, all these decisions we read from the judgments are outcome of the writ petition that is filed by the High Court. As we are aware that as a chartered accountant, generally, whenever there is matter relating to income tax, relating to GST, we go through the appellate mechanism. At times, we don't think of writ petition. And there are three reasons for that. One is, as far as writ petition is concerned, it is believed that maybe chartered accountants will have limited role to play, so they don't indulge into writ petitions. Secondly, at times there is a fear that there will be substantial costs, and those who are away from the city where the High Court is located, again, the costs are prohibitive. But then when we had certain presentations, in fact, this committee is also coming out with booklet on writ petition, which is authored by Suhas Bora and Sanket Bora and others. So there we realized that this is very useful weapon, particularly in case of GST, where you prefer an appeal. I am told that certain tax has to be paid. So if astronomical demand is made, then in that case, it would be difficult even to pay some percentage of it and to go in appeal. So these are the circumstances where I think writ remedy merits consideration. And it is not that the chartered accountants do not have any role in this particular writ remedy. Maybe they have all the groundwork available. So if they understand what is the rights in writ, what they can do, certainly they can assist in drafting, in guiding the counsel for the purpose of making a writ. And ultimately, in case of representation before the High Court or any other authority, a chartered accountant can play a great role because he is the master of the facts. Only thing is that he needs to understand the law relating to the writs. So considering the importance of this particular weapon and not very liberally used by the chartered accountants, the judgments which I cited right now, and these are few of the judgments, routinely in case of faceless assessment, there is an SOP that whenever any order is to be passed following the hearing, a draft assessment order has to be presented to the assessee. Bypassing this particular rule, straight away assessment order is passed. And we have seen whenever such matters have gone to writ, in that case, not only the relief has been granted by the High Court, but costs have been awarded against the department. So now department is also put to notice on various matters, particularly relating to the section 80 IB, where substantial demand arises. Then even paying 20% or remaining under the tenterhook of this particular appellate procedure, maybe for 5 years, maybe for 10 years, it would be very difficult. And we have noticed that Sanket has successfully argued certain cases, and the relief that could have been available after 5-6 years, maybe it has become available between 5-6 months. So that has impressed us to really thought into this particular area. And therefore, we have invited these faculties, Suhas and Sanket, who have authored this particular book, this Bhunesh, who is a chartered accountant but practicing on a law side. He is also appearing before the tribunal and High Court. So we thought that maybe let us have their expertise. I also thank CA Rekha Damadkar, who is also former chairman, who will be moderating the question and answer session. So with this, friends, we are in for great value addition with experienced faculty and knowledgeable inputs, which will certainly provide us a very handy tool for the purpose of practicing in direct taxes or indirect taxes. Of course, in other matters also, wherever we think appropriate, we can make use of this writ remedy. Thank you.
Thank you, sir. Thanks a lot for brief introduction and enlightening us on the importance of writ remedies and opportunities for the professionals. I now introduced our speaker, eminent speaker of the day, Suhas Bora, sir. He's a practicing chartered accountant since 1987. He is founder and senior partner in SPCM and Associate, renowned firm from Pune, practicing in the field of direct taxes, company law, RERA, indirect taxes, special invitee on direct tax committee, co-opted member of capacity building committee by ICI, co-opted member of direct tax committee of ICI, impaneled as quality reviewer, impaneled as peer reviewer, honored to be member of fee fixation committee of Bharati Vidyapeeth deemed university, approved valuer, also approved valuer appointed by income tax department. The profile is very big profile, sir. He was the chairman of Pune branch in the year 96-97, member of Pune Governing Council of Federation of All Over India Traders, chairman of CSL of Jito, regular paper writer, regular faculty in various seminars, conferences on income tax, different topics in the interest of profession. Also renowned speaker in the field of time and stress management, founder member activity faculty of Pune Study Circle, and also dynamic faculty of Pune branch of WARC. He is always support to the Pune branch for all the programs we conduct. Active member and advisor on for various social and charitable bodies such as Jito, Pune, Punjab Coal Trust, Maharashtra Saraf Association, Federation of Trade Association, CREDAI, Pune Merchant Chambers, and many more. With this brief introduction, I request sir to enlighten on the topic. Sir, you are meet.
Yeah. Respected chairman and my friend, chairman of the committee, Chandrasekhar Chitreji, other esteemed members, colleagues, at the outset, happy evening. It's a special moment for me on the two front. One is when I see all the panelists and the moderators, including chairman of our committee, all are past chairman of Pune branch. And it's been really delighted to see all the battery of past chairman of the Pune branch. Second moment is for me that first time, myself and my son, Advocate Sanket, we are having on the same platform of the ICI. That been really a dream come true for me. Friends, in today's evolving legal challenges, Shekhar has rightly put on few number of cases wherein we can think about a writ remedy. And writ remedy has been again a vital tool which we can think about. Because right now, in a range of or era of the faceless assessment, what has been happening is that what we are submitting and what has been taken care of by the AO, we have no control. And therefore, it resulted in the high pitch assessment. High pitch assessment for no reason. There rightly been pointed out again by Shekhar that yes, when high pitch assessment is there, there is a huge demand. And that demand to make it payment, none of the lower authorities in spite of various Bombay High Court decision, judicial tribunal decision, there are no powers to them to make it less than 20%. And that 20% amount to make a payment, it becomes a Herculean task. To share with a few practical examples in our own offices, I can share with you a small trader. In his case, what happened? There is some bank in the Bihar. That manager has wrongly put on some PAN number, which unfortunately belongs to that SSC. And there were crores of rupees were deposited. And that information come into our portal. And AO has asked the explanation, which he could not, in spite of the fact that he has given, he could not travel to Bihar to ask that bank to from where he is there to work. And for him, there was no remedy available. There was crores of rupees has been added. Demand was been such where he has to just to think about having suicidal. In such cases, it is always a writ remedy which can prevail to us. Similarly, we find in many occasions there are lot of incorrect reporting by the registrar authorities. Few cases when there is a purchase of property, they intimate as a sale of property. You cannot travel to those people to make correction. Even in case of banks also, when there are numerous fixed deposits are there and those are being redeemed and reinvested, couple of times, twice or thrice time that has been reported, and it is very difficult to find answers to it. Technical issues which Shekhar raised up of non-passing of, not giving up the draft assessment order, not following the procedure laid down in section 114B, 44B. Then there is various issues where even the CIT appeal, you can find it, they don't consider at all any submission which has been filed by you. And this one will almost become an ex parte order which has been there to work. In such cases, no doubt, the appeal mechanism which has been provided in the appeal proceedings of filing CIT appeal, tribunal, then High Court, or a revision petition under section 264 are also been vital. But that remedy, it takes a time. And to come out of that, normally we as a chartered accountant, we are being rightly said by Shekhar, we are not following the process of towards the filing of a writ petition. Maybe simple reason behind that we need to travel to Mumbai or we have to find an advocate in Mumbai to brief him and then take care of the cases. Also, we find that sometimes even SSCs are reluctant. They said again, government ki against High Court mein kaise jaane ka hai? Kuch hoga tha mujhe. So we have to upgrade first of all ourselves. We have to upgrade our SSCs. That is the right for them. It's a right legal remedy available to them to face up, to file in the High Court jurisdiction by of a writ, and then see that the results are also coming in time, which will affect on the SSCs to work out, and it will save tremendous time for him as well as his money, which is going to be locked up for a number of years. We are all aware, once you make the payment, to take the refund from the department is also become a Herculean task. And that task we have to face up again. We find that in many occasions they issue the refund, they don't give any interest on that. There are numerous cases which Sanket will share with you in our present today. You find that even VSVS, when there is a legal refund was available in Form 5, still it is not given almost more than 2 years to work out. And we have to approach the writ. In case of release of jewelry, also in case of search cases, lot of jewelry has been there, which is not been able to be released for no reason. Even SSC also forgets to work out. In such cases, to find it, because now because of the faceless, again, there is a lot of change in jurisdiction. No SSC is not aware which jurisdiction he has to follow. So in such cases, I believe writ remedy is not only in the assessment, but in the grievances like stay, grievances like release of jewelry, grievances like claim of refund, even for the early hearings. I have occasion to deal with a case where a lady is of almost 91 years old. She is suffering from the cancer. Her appeal has been, again, it was assessment has been created only on the basis of some reporting by the financial institution, which is patently illegal, you don't find it. 3 years appeals are not coming for the hearing. We are finding again VSV scheme has been announced by Honorable Finance Minister for the checkup, saying that there are a lot of pendency of appeals to work. But we are all witnessed, all we have been there who have been reporting before CIT appeal in the tribunal. We are knowing CIT appeals are not coming for last 3 years. And therefore, my suggestion will be to all who are the participant, we should use this remedy, which is legally available to us. And definitely all the panelists and the speaker, even Bhuvnesh also will share his wisdom of the writ remedies available to us. Let us start with that. Once again, I give my heartfelt gratitude to Shekhar for giving this as an opportunity to speak on the opening remarks for this webinar to address. And thank you very much, Rajesh, for giving a nice introduction. Over to Rajesh.
Thank you, sir. Thanks a lot for briefing on the subject. Very useful. You have covered all the practical aspects which industry is facing, be it a faceless assessment, be it rates, search, seizure. Thank you, sir.
Just before that, as he rightly pointed out, say in case of property, if the property is of 4 crore and there are 4 owners, each of the 4 owners get the AI reporting that he has sold property of 4 crore.
Yes.
Whereas his share is only 1 crore. And then all the 4 face the music. So
Yes.
things are happening like that.
Yes.
Yeah, thank you.
I also
Yes,
heard
yes.
many cases related to gold seizure and not released in time. Thank you, sir, for enlightening us on the topic.
Yeah.
I now like to briefly introduce Advocate Sanket Bora, managing partner of SPCM Legal, a full boutique firm, legal firm, offices at New Delhi, Mumbai, and Pune, specialized in taxation, corporate law, real estate, banking, and constitutional law. Practices before MREAT Mumbai, DRAT Mumbai, SISTAT Mumbai, NCLT Mumbai, NCLAT Delhi, Bombay High Court, Delhi High Court, and Supreme Court in India. By education, he has completed LLB, LLM, BSL, accounting technician from ICI, diploma in corporate mergers and acquisition from Symbiosis College, advanced diploma in cyber law, certificate course in real estate law in India. With this brief introduction, profile is large. With this brief introduction, I like to request Sanket to please have a look on subject.
Right, sir. Am I audible?
Yes, yes.
I'm audible now?
Yes.
Rajesh ji are very kind by saying that I would say profile is very large. But after going through the profile of my father, C.S. Bora, I'm sure I'm miles away from filling up the profile. The profile is just so small at the moment. But I'm sure with the blessings and guidance of all these chartered accountants, esteemed panelists, I'm sure the profile will grow with time. The topic is something that is very close to my heart. Very recently, the chairman of the committee had given me an opportunity to make a primer on this subject, which is quite trending in the last few years, I would reckon. Writs have not been so popular in the taxation scheme as much as it is now. Earlier, the entire hierarchy of appeals, which is, as rightly said by Suhas, there was the CIT appeal and the ITAT, and then eventually the second appeal before the High Court under Section 260A was preferred, and largely so because of the lesser dependency of appearances that was required. But now, considering the pendency of appeals, the time that has been taken to adjudicate upon issues, the ever-changing, evolving laws, and the various reforms that have happened in the adjudication reassessment regime, search and seizure regime, the GST that was introduced in 2017, the chartered accountants are saddled with so much of updation that needs to be done. Whereby I reckon that sometimes simpler things, if you could point out writs would be a better remedy, is what I would recommend. I had a brief talk with the next panelist that would be coming in, my friend, advocate and chartered accountant Bhuvnesh Kankani, who would also be apprising the participants with respect to the writ remedies available, especially with respect to tax. But to speak about writ remedies, I reckon there would be a question answer format eventually, Rajesh.
Yes.
So I'll just sum up.
Participants can
Right.
give the questions. We will take after this discussion.
Okay, so at the moment, should I continue with the
Yeah, you
topic?
continue, please.
Very well. So, if Suhas sir has started with the tone of giving examples, even Chidai sir has given such good examples of writ petitions, I like to, rather the overview of writ would be eventually be given by Bhuvnesh. But just to sum up, writ petitions are a constitutional remedy. They do not come in from a statute. The Constitution of India provides writ, which is under Article 32 before the Honorable Supreme Court, and under Article 226 before the Honorable High Courts of the territorial jurisdiction that we are in. Writ under Article 32, basically, that is, if you have to approach the Honorable Supreme Court, you have to be aggrieved, or your fundamental rights as enshrined under the Part 3 of the Constitution of India needs to be uh, infringed upon. Whereas writ under Article 226, which is more commonly used, which is before the Honorable High Court, you could approach if any of your fundamental rights are infringed or for any other purpose. This is what the text of Article 226 says. So it's quite large, it's quite wide, and basically it is also for enforcing your legal rights. There have been various cases whereby even when there is alternate remedy available, writ petitions have been entertained or they've been disposed of with. Now, it's a discretion before the Honorable High Court whether they would allow an extraordinary remedy such as a writ to be exercised. So we need to understand that which are the cases that would typically fall under the writ jurisdiction before the Honorable High Court. Sticking to Maharashtra has got the Honorable Bombay High Court, which has the principal seat at Bombay, and the three other benches, which are at Nagpur, Aurangabad, and Goa, all having their original jurisdictions, their territorial jurisdictions. So territorial jurisdiction is something that we should first understand, is that, say, for example, an assessment order, an impugned assessment order has been passed in, I would say, Amarnagar. Their ITAT, even though is Pune, but their territorial jurisdiction of their High Court comes to Aurangabad bench of the Honorable Bombay High Court. So writ has to lie before the same territorial where the impugned order or where the cause of action arises. So with that said, writ petitions per se are of 5 types. Bhuvnesh would eventually give clarifications with respect to that. But the 5 types are habeas corpus, quo warranto, certiorari, prohibition, and mandamus. The more commonly used with respect to tax are mandamus, certiorari, and prohibition. Now, what would mandamus eventually be used for is basically the courts are giving directions. For example, assessing officer has just sat upon a refund that is way overdue. So he is not acting in accordance with law. So whenever his inaction is causing any grievance, you may approach the Honorable High Court to issue a writ of mandamus to that assessing officer that he needs to pass orders. Likewise, certiorari is basically sits like an appellate court, whereby if an notice has been issued without jurisdiction, or if an order is passed in excess of jurisdiction, certiorari basically sets aside and quashes the said order. So it is the High Court then plays a appellate court's role, whereas prohibition is curative in nature. For example, assessment order is passed and eventually a penalty order is initiated. A penalty is initiated, proceedings is initiated. So prohibition basically states that any consequential notices or orders that would be passed thereon would be stayed through the writ of prohibition. So these 3 writs are majorly used with respect to taxation in per se. There have been various cases very recently that have been used where alternate remedy itself is not available. In such cases, also writ petitions are preferred, such as the income disclosure scheme that had come in 2016. Various issues had cropped in with respect to the income disclosure scheme, whereby no appeal was provided. In such circumstances, writ was the only remedy, and hence writ is basically the last resort or the first resort, depending upon a case. Usually, it's the last resort. With respect to uh, the Direct Tax Vivad Se Vishwas Act, there have been n number of cases that have been adjudicated through the writ petitions because there is no appeal mechanism provided in the statute. Uh, and then there were n number of erring orders that were made, n number of decisions that were passed by the PCIT accepting or rejecting an application under those statutes. And hence, writ petitions are very much important for a chartered accountant. It's a weapon that could be used to remedy a wrong that has been done to the assessee or to the client. To my experience, writ petitions, why are a little faster is because similar cases, since income tax has provided so many amendments recently, and those amendments have been adjudicated before the High Court. If they would not have been adjudicated through a writ, probably the entire hierarchy of appeals that could have happened and the number of people that would have been affected only because of non-adjudication of a question of law at an early stage only creates cascading effect of appeals. And hence, if there is a new question of law which has not been answered earlier by any order or dictum given by the Honorable High Court or Supreme Court or the ITT for that matter, such cases writ ought to be preferred, especially if it's purely a question of law. Whenever it's a question of fact, obviously a writ petition, being an extraordinary remedy, it's not a fact-finding authority. So hence, question of law, whenever is to be dealt with, very recently, the Honorable Supreme Court stated that even if there's an alternate remedy available in form of CIT appeal or the ITT eventually, writ ought to be considered, exercise. It's no more a discretion if it is purely a question of law. So, a question of law definitely it's a technical legal ground. Writ ought to be preferred. Various high courts, especially the Bombay High Court in this case, has got a specific tax bench. So I would say when a tax bench is constituted, they've been going through the provisions of the Income Tax Act so often that the earlier people that used to say that, usually by the time it reaches a second appeal before the Honorable High Court, the judges are not fully acquainted with the tax laws and the nuances and the jurisprudence of tax law. But now probably that is not the case because the tax bench is handling, thousands of matters during the year, which happen to go through a number of provisions very meticulously. They've been assisted by various councils meticulously, obviously through the instructions of chartered accountants, who very ably brief them the matter and the facts and the jurisprudence with respect to the same. During a writ petition earlier, the change has been that the system used to be that first the writ petition used to be admitted and then eventually it used to be kept for final hearing. But now, considering the pendencies before the High Court, the High Court usually prefers that writ petition need not be admitted. Instead, they could have disposed of the writ petition when both the parties were waive of their service of notice and would want to, argue the matter right away. So, reply rejoinder, and that's it. So, probably in a couple of hearings, or not more than 5 hearings, the writ petitions are disposed of. So, hence, that could also be one more advantage of why writ petitions ought to be preferred. Likely, the court fee for filing a writ petition is at High Court is 250 rupees, and likewise every other High Court that I have experienced is not more than 500 rupees, exceeds 500 rupees. So even that is not an extraneous burden on any of the assessees. So per se, so many advantages. Disadvantages probably, yes, as Suhas said, that there is an anxiety with an assessee that if you approach the High Court directly, whether there would be an in pressure coming in from the department, or would the chartered accountants face the tune of the income tax department for advising their clients to directly approach high courts? Because at times the high court exceeds the expectations of the assessee and also penalizes the assessing officer, the hearing officer, which usually is not taken very lightly by these officers, and hence the anxiety surely comes in with the assessee. But uh, while I'm working on the primer on the writ petition, I would be addressing various points and the intricacies involved with respect to writ petitions before the Honorable High Court, especially with respect to taxation, not only with respect to direct taxes, but also with GST and other allied laws, such as the Companies Act, where writ petitions are frequently used for revival of companies and so on. Since NCLT also at times have erred with respect to interpretation of various provisions. With that, I think, Suhasa, if you could add something, and if there are any questions, probably I would be able to answer.
Yeah. Being this is a national program, whenever there is a case of Bombay High Court, we can read the respective High Court. And now I request Suhas if he want to add anything.
Yes, for the participants, I just wanted to make out that we come across a scheme of IDS. And in IDS, many occasions what happen, some people have paid first installment, some people have paid second installment, and they could not make out for the third installments to account. So department has taken a stand that in the IDS, there is a provision, there is no refund of amount of the tax which has been paid will be given. Again, on the basis of same IDS declaration, there is 147 proceedings has been came across. So credit for taxes which he has paid in the IDS was claimed not given. That SSC eventually went across, again DTVS come, so then he approached to DTVS also. So there also again, because the same income has been offered, tax has been collected again twice with interest. So he again requested not to penalize him because he has already paid the taxes, that credit has to be given. There was no remedy available. In such case, writ is the only remedy available, and where Sanket will enlighten on that case which he has himself argued, and that become a landmark judgment for the entire India is concerned. So I would like Sanket to clarify that special decision which you argued and get the success.
Okay.
It is
This
reported
case
decision
is-
now.
Right. So this was the case of Pinnacle Vastu Nirman versus Union of India. The facts were that the petitioner had defaulted in his entirety of the payment under the income declaration scheme. Eventually, reassessment notices were issued since his declaration under the income declaration scheme was defaulted and had to be honest. So reassessment proceedings were initiated, tax was levied, and penalty was levied, assessment order was challenged before the Honorable CIT appeal, and while the pending of the CIT appeal, the scheme of Direct Tax Vivad Se Vishwas Act was introduced. He made an application before DTVSVA, and DTVSVA, while issuing the Form 3, had demanded tax without considering that the tax under IDS was also paid. So the assessee, obviously the petitioner, could not afford to bring in more money. At the same time, it was nothing but forfeiture of that money, which was not allowed under the authority of law. That was the case, and the Honorable Bombay High Court, when they issued the favorable order, they took an opinion that this would not, the forfeiture of amount would be in the teeth of Article 265. So 265 basically that the authority would not take any amounts as tax. No tax shall be levied without authority of law, save and otherwise without authority of law. So this would, without any provision allowing for forfeiture, they would not have forfeited. They had to adjust that money. Secondly, since it was the same income, even though paid under IDS, which was under Finance Act 2016, it could have been adjusted against Direct Tax Vivad Se Vishwas Act because it was qua the same income and it was the income tax. It is not that a GST challan was supposed to be setting off against Direct Tax Vivad Se Vishwas Act. So basically, at times, going through the provisions, the interpretation of the High Court is more of common parlance, and I feel that, rightly said so, this was not challenged by the Union before the Honorable Supreme Court. Hence, it is a good law, at least for the state of Maharashtra. And in case an IDS does come again, I'm sure that this would be helpful. Besides this, there was a case very recently uh, with respect to a 264 revision petition. When a 264 was filed, the principal CIT would not allow or would not refer to ITAT judgments, saying that these ITAT judgments are not acceptable to the department, and they filed an High Court appeal. Without having a stay by the High Court in such ITAT judgments, he would merely dismiss the 264. The Honorable High Court came heavily down upon the PCIT, stating that the judicial discipline has to be followed. If the jurisdictional ITT has made an order and it has not been stayed or reversed by the Honorable High Court under 260A, it has to be followed in toto. No subordinate authority can say that we do not accept an higher judicial order. So that judgment showcases that 264 has got a huge role by the PCIT, and while he is exercising this huge role, he has to consider all those judgments that have been given. There have been cases, especially with respect to orders not being in a speaking manner, no reasons being recorded. They've been arbitrary, they've been mechanical, they've been copy paste orders, as we rightly say. In such cases, also, high courts have come heavily down upon. Delhi High Court has been very vocal about this. Madras High Court has been very vocal about this, and so has the Bombay High Court being very vocal about this. That any order, there's a saying that says that it should reveal the unscrutable face of a sphinx. So a sphinx per se is those monuments that we find in Egypt with a cat as its the body of a cat and a face of a human. So it should reveal the unscrutable face of the sphinx. So order should be such that anyone who reads it should understand why it has been rejected or why it has been accepted, and the facts thereon. The reasons have to be very clear. So even having a non-speaking order is a violation of principles of natural justice. So these cases are very routinely taken up before high courts. There have been very rare cases, but however, I like to put in, some light upon judicial bias or any sort of bias that comes in play. These, even though I do not have direct citations with respect to specific cases, but there have been certain cases where there is absolute bias. You can find out that if a certain assessee or a certain representative is appearing before a specific bench, that specific bench usually, in its usual course on identical facts, takes a very different order, whereas if a specific legal representative is appearing, he passes an order which is usually adverse to the assessee. In such cases, I would say this would be struck by bias. It involves bias, and again a violation of principles of natural justice. This, I have filed in. I will be filing in a writ petition with respect to something like that, wherein a tax practitioner has approached me. We finalized the writ petition and would be soon circulated before the Honorable High Court. Hopefully, that is appreciated by the Honorable High Court, and such types of cases henceforth do not happen. There have been cases where the ITT has gone beyond its powers given under the rules of the ITT. There was one recent case whereby the Honorable Mumbai Tribunal had made an order to an assessing officer to reopen assessments with respect to various people who were not parties, obviously, to that appeal. They also made various other directions which the ITT could not have under the ITT provisions and the powers that have been vested with the ITT. The High Court set aside those strictures and orders that no such directions could have been given by an ITT to reopen someone else's case. So ITT, being an independent tribunal, has to follow its own procedure. At the same time, under the powers that have been granted to them, a number of cases with respect to miscellaneous applications under 254(2), that whereby the Honorable High Court and Supreme Court have stated that 254.2 orders under section 254.2, that is miscellaneous application, cannot be filed as a second appeal under 260A, even though the doctrine of merger applies. So the Honorable Supreme Court and High Courts have stated that against an order under 254.2, only a writ petition is maintainable. So 254.2 is with respect to error apparent on the face of record. There have been cases by the tribunal, by the revenue, that have been filed, that subsequent judgments, while the orders were passed by the tribunal, they passed it on a judgment of a specific high court. Eventually, that judgment gets reversed by the Honorable Supreme Court. So whether those ought to be error apparent on record or not, there have been different views on this. But then, whenever such a thing happens, the only remedy that is the Honorable High Court under the writ jurisdiction. One interesting case that I would like to say about miscellaneous application itself, when the Direct Tax Vivad Se Vishwas Act came in, and it's a funny thing that it's almost the same in the Finance Act 2024 proposed scheme. When they came up, they did not, refer to 254.2 being a pending appeal. So it was constituted as a pending appeal. But they came up with an FAQ 61 in a circular under 119 to clarify certain positions. And as per that FAQ number 61, they stated that only those miscellaneous applications that were filed against an appeal dismissed in limine, only those would qualify and be eligible under Direct Tax Vivad Se Vishwas Act. And we had challenged this before the Honorable High Court. We challenged the circular under the Honorable Bombay High Court being violative of Article 14, which is equality before law, which is a fundamental right enshrined under the Constitution of India. And the Honorable Bombay High Court struck down the said FAQ number 61 and stated that such a additional qualification and a classification made thereon with respect to 254.2, that only those which were against an appeal which was dismissed in limine and not against those whereby a speaking order was passed is violative of Article 14 and hence struck down. So very important decisions with respect to challenging of buyers. There have been a number of writ petitions that have been filed challenging the Finance Acts. 2021, the one before the Honorable Supreme Court, Bombay High Court has dismissed the petition of the Serum Institute challenging Finance Act 2021, whereby the definition of income was amended retrospectively. Now that has gone before the Honorable Supreme Court for its due consideration. But challenges have been made to the buyers of Act. As chartered accountants, I would urge that whenever orders have been passed, scrutinize under which section has the order been passed. A very interesting thing is that under DTVSVA, Section 5 provides that the earlier 2020 Act provided Section 5 that the PCIT is a designated authority, whereby in all the cases that I have come across, orders have been passed by DCIT saying under 5 subsection 2, whereby refund is to be granted or not granted. So I would say those are absolutely without pass. So that needs to be scrutinized by chartered accountants.
Thank you. Thanks a lot.
Yes, sir.
Yes.
Right.
Excellent addition. In fact, whenever there is an injustice to the assessee, we can approach writ. And this is a very, we can say it is a Brahmastra with the assessee to play against the injustice. Thank you very much for sharing your case studies and addition for the benefit of members. I request Rekha Madam to continue with some questions with Sanket and Suhas sir for the benefit of members to enlighten on the topic.
Thank you, Rajesh. Thank you very much. Am I audible?
Yeah.
Thank you very much for inviting me to ask the questions. First of all, I would like to welcome Sivi Chites, our Central Council member, Sanket Bora, Advocate Suhas Bora, and Kamlesh Kankanani, Rajesh Agrawal, and Mayank Vasudevan, and the technical team of ICI and plus the committee members. Thank you very much who are present here. I think for a chartered accountant, it's very difficult to understand the legal technical language. Okay? So I will be asking a couple of questions in a very plain and simple language, which can be understood by the chartered accountant very well. You may find it repetitive. You already explained about the jurisdiction, the types of the rates, and when it is to be filed, and in what situations it is to be filed. But I would like to ask some questions which may be repetitive of what you say, but I think those cannot, or since it's technically explained, it may be repetitive. So extremely sorry if I ask repetitive questions. So I will be having just 5-6 questions. First question is, who will be the beneficial or who can take the benefit of this alternate remedy? And if the appeal is not filed, the assessee is not taken advantage of filing the appeal, he hasn't performed his right to file an appeal, can he go directly to the High Court to file the writ petition? I think you already answered, but I would require the specific answer to this question.
See, filing of appeal is being right definitely available to the SSC. But if there is a question of law, if there is an injustice patently, then probably filing of writ is a correct remedy. And Sankita has in detail explained why it has been there, or even Shekhar and myself, we have narrated the provisions where you are finding it's injustice to it. There has been a high pitch assessment. In that case, instead of filing appeal, it is better to file writ petition. But always we have to keep in mind, if you file an appeal, then and then you decided to go for writ remedy, then first of all you should withdraw the appeal filed by you. Reason being is that on the same technicalities again, if you are using the remedy available in the act which has been there, then writ remedy will be of interest to us to make out. So therefore, precaution has to be taken when you are wanted to file the High Court. Don't file appeal, or if you have filed it, kindly withdraw that appeal which has been filed and pursue the only writ remedy.
I think on timelines also, if Sanket can explain that for appeal, what time
Yeah.
it takes for hearing and appeal,
Yes.
how many?
Yes.
So can it be the can High Court say the appeal writ is not maintainable just on the ground that the appeal is not filed? Can High Court take a stand that writ is not maintainable just because the assessee hasn't performed his right to file,
Right.
or can he file simultaneously?
Right. So
can withdraw that?
yes. So basically, when you approach the Honorable High Court under writ petition, the High Court would like to understand that the same relief that you're seeking under the writ provision, you have not done that before any other forum. So CIT appeal, you are seeking for the same relief that the assessment order be set aside or the order be set aside. So likewise, hence the doctrine of res judicata comes into play before any forum. So if you're asking for the same relief before two forums, one of the forum has to say that now we cannot entertain you because the other forum is going to. So the basic principle is either you file a writ or an appeal. If you file an appeal, you shouldn't file a writ, and if you're filing a writ, you shouldn't be filing an appeal.
Sanket,
Can it be filed
yes, sir.
simultaneously?
will you please guide the participant on the limits which have been there? And because in the regular remedy of filing through CIT appeal tribunal, it takes n number of years. And if you file the writ in the High Court, what is your experience of filing an appeal and getting the results?
Right. So very recently, I would say, first of all, timelines per se, they have not been defined under any of the rules that the High Court has to dispose of a writ petition within a specific timeline. However, the cases have been that, as I said, the procedure per se, true procedure before every High Court has its own rules, how a writ petition is to be disposed of. There are High Courts like Madras High Court, whereby writ petitions are usually before a single bench. Whereas in Honorable High Court, when it comes to income tax matters, writ petitions are before a division bench. Before Delhi High Court, it's before a division bench. So the likeliness of a division bench sitting and hearing cases, the timelines differ. However, yes, sir. So basically, I would say writ petitions, considering today, right? Considering the today's experiences, writ petitions are much faster, only because they don't have to look into the entirety of the appeal records. They have to go through the question of law. They have to look into the impugned notice or the order, and then pass orders. So currently, most of the high courts, they are much faster in the writ jurisdiction than any of the appeal mechanism.
Yes. Thank you very much. My next question is coming to the limitation point. I heard that these remedies, is it true that the alternate remedy to file the writ is not maintainable if the time limit to file an appeal, original appeal, is over?
Per se, there have been,
Or can
different
it be
views
filed
taken.
with delay
Yes.
condition
So as you rightly said that there are limitations provided under statute for filing of an appeal. Also, along with that, they have given the powers for condoning delay. Likewise, when it comes to a writ petition, there are no timelines that have been granted that within what time a writ petition is to be filed challenging a certain order or the statute or anything. So, but a writ governs itself. The courts govern themselves by a doctrine of delay and laches. So it says that if there is unreasonable delay or unreasonable delay by the petitioner in approaching the High Court under writ jurisdiction, they will not exercise their writ. So what is unreasonable again is subjective to the facts of the case. Why the petitioner could not approach the High Court? They look into the circumstances, the background of the petitioner, the area where he comes in, the income and the status of the petitioner. All these facts are considered eventually, but I've always come across the High Court have taken lenient view. There have been cases whereby the High Courts have entertained writs that are, even though CIT appeals, the limitation is 30 days, writ have been filed after 3 months, 4 months, and High Courts have entertained those writs. So there, per se, High Courts, when it comes to writ petitions, specifically on question of law or violation of principle of natural justice, they've taken a lenient view, even if there's a delay in approaching it.
Yeah, but you explained about the natural not following the natural justice and taking the lenient view. But my question is, if the CAM court deny or did you maintain High Court deny to maintain the application writ petition if the time limit to file an appeal is over? Because I read a couple of cases where the High Court taken a stand. It might have been overruled, but basically whether it's correct to take such kind of a stand.
Right, I'll say. Whenever a writ petition is to be filed, it is a self-declaration by the petitioner. He has to affirm it on affidavit. So there have been cases where the petitioner has been silent on the entirety of the delay. In such circumstances, the High Courts take that stand that we are not going to exercise our powers under Article 226 and we dispose of your writ petition without using any discretion. But if the delay has been explained, well explained, for example, there was a writ petition whereby a delay of almost 4 months, 4.5 months was made. The 30-day after the 30-day period of the CIT appeal had gone away with. We had given the reasons. The reasons being there was death in the family. She was a widow and she had no knowledge of income tax proceedings and thereon. So all these facts were considered by the High Court and they did acknowledge the delay and yet chose to use their discretion. Again, this is a discretion. There's no absolute right that a person has to appear before to approach the Honorable High Court in such circumstances. But even though this is an absolute discretion and it's a huge power, they have made certain own self-imposed restrictions, and one being the doctrine of delay and laches. Secondly, ideally, any order you cannot challenge before the High Court. There are certain factors to it. There are certain grounds to it, which I'm sure my learned friend Bhunesh would be elaborating much more in the further this thing. But just to summarize them, one is principle of natural justice. You can always approach the High Court. The second is challenging the bias of a statute, which you cannot do before a CIT appeal or the ITT because they don't have the powers to strike down a law. And the third being if it's a pure question of law. And the fourth, obviously, being that if your fundamental right has been infringed. So if there is a specific provision that says only an specific person is excluded from it, unless and until there is a reasonable differentiation why that person was excluded, it is violative of Article 14. If a specific person is, if a specific provision has come across whereby the entire trade of that person will be, the going concern will be at threat, that would then, I would say, attract 19(1)(g, which is right to trade and profession. So all these things you can directly approach High Court, and there again delay would not be an issue.
Okay. So in both the cases, I got the answer that in case of principle of natural justice, in case even the original appeal is not filed or the time limit to file an appeal is over, the person can go to High Court, okay, with the application of contempt. Okay. So next question is the remedy of alternate remedy is available to file the if the writ petition is filed, alternate remedy is used and the writ is filed. So can it be bar for reopening the assessment or reassessment while in the pendency of the writ?
Come
See,
again.
So my
May I address?
question is, yeah, if the writ is pending in the pendency of writ, and if the alternate remedy is not available, not used, and the writ is filed, and during the pendency of writ, can the assessing officer reopen the assessment or pass the order of reassessment?
Rekha, in this case, that subject is the same, so on that basis he cannot. But however, if there is certain additional information has been found out, say for example in somebody's search, there is a noting has been found out, and that is not been considered in the order which has been already passed and have been filed before the High Court. In that case, definitely AO has power to reopen the assessment on different ground, not on the same material, on the same fact.
I would say that
in this case, then the writ can be filed and simultaneously the assessing officer can execute his powers to do a search and all that. That is that.
No. See, powers under section 147. Originally, if it is there is 147 has been passed on certain information. Later on, certain information has been again found out, and material he has reason to believe that that is also been escapement of income. There is no bar on reopening on that again additional information to her. Sanket, if you wanted to add, yeah.
Yes. So I'll say
once the writ is filed, the powers to assess and power to search all gets exhausted.
See, I'll tell you, just mere filing of writ petition per se would not affect any parties. There has to be notice that has to be issued by the High Court. The High Court has to first take cognizance of the matter. They may pass an interim order of stay of proceeding. Only then, per se, I would say that the matter is not sub judice before the High Court. Mere filing would not make an embargo on the respondents or the department to not further proceed on various assessments or actions. So unless and until the High Court takes cognizance, makes an interim order, issues notices to the respondents to file their reply on affidavit, meanwhile the assessing officer can do his duty as bound by law.
Okay, so he can reopen and the assessment, or he can reassess, pass the order for reassessment during the pendency.
On different issue.
Okay. Is there any requirement like when filing the appeal, you need to pay a certain percentage of the taxes? So what is the procedure while filing the writ? It's very basic.
Right.
I don't have.
Yes, absolutely. So every High Court has its own procedure. In Bombay, there is the Bombay High Court original side rules. There is Bombay High Court appellate side rules. Delhi has its own original side rules and appellate side rules. Every High Court has its own rules, and the rules govern their procedure with respect to writ, and the court fee is assigned to that. In Bombay, it's 250. In Delhi, I reckon it's 150 rupees. In Madras, I'm not sure, but I reckon it was much lesser than 500 rupees, but it is not ad valorem of the duty. Unlike the 260A appeals, when you have to file before the Honorable Bombay High Court, the maximum court fee is 10,000 rupees. Again, it is ad valorem to the tax effect. But when it comes to a writ, it is not ad valorem.
Sanket, probably Rekha is asking, like in case of other appeal route, we have to pay 20% of the demand outstanding.
Oh, right.
Whether that has been there in the case of Writ also.
Right. So I'll, in cases of Writ, as I said, its own procedure, its own discretion. Income tax cases I've never come across where the Honorable Bombay High Court has not given a stay order uh, without asking them to deposit certain amounts. But there have been cases on the civil side where have appeared challenging probably the adjudicating review orders made under by the IGR, that is Inspector General of Registrations, in a stamp duty matter, whereby the court first said that yes, we are granting you interim, but at the same time we do not want to make a loss for the revenue. We want to protect the interest of the revenue also. So you also deposit the 100% amounts with the registrar of the Honorable Bombay High Court. So again, it's a discretion. Under the tax, at least, we do not come across cases whereby deposits have been requested by the High Court.
Okay, but once the writ petition is filed, then the demand at the assessing officer's level are stayed, automatically stayed.
No, as I said, mere filing of writ. Yes, mere filing of writ would not stay the demand. You have to seek for the interim relief, that is stay on the assessment order and the demand notice under 156. And once that is granted, it is stayed.
Okay. So likewise, once we file the appeal, the demand is stayed automatically. It's not the case with the writ.
No, even an appeal, I would say, because there's a circular of the CBDT of 2016, which says that on filing of CIT appeal and payment of 20%, it's an automatic stay. But under a writ, per se, there is no automatic stay, only on mere filing.
Okay, and the interest and penalty for the period of dispute is adjusted against as it is as in the other case. The interest for the period of dispute can be, I think, adjusted against
excluded. See, eventually, if the writ, right. So eventually, if the writ petition succeeds,
yes, succeed.
If the writ petition exceeds, nothing survives. So penalty and interest also is waived off if the assessment order itself is set aside.
Okay, sir. Last question. I think you already answered, but for the benefit of the participants, I would like to ask this: if whether it is beneficial in the case of time manner, in case of the fees we need to pay to the High Court lawyer, or we need to deposit the time required. So is it feasible to go to the file the writ as alternative remedy? That's the last question from my side.
I would recuse myself from answering that because there's a direct conflict of interest here. Being an advocate, I leave it to the other esteemed panel, CS Suhaji Bura, to answer on that.
See, Rekha, we have to take call. As I said, the Shekhar and myself, we were saying in the beginning also, we always normally reluctant to go for writ remedies because of these natures. But right now, I believe if you think about time which we required for the normal following the route, which has also been vital provisions available in the Act, is CIT appeal tribunal. It goes with a lot of money has to be paid, and even if you consider the cost of interest on that money which has been blocked, and considering the time consumed for getting the refund back, even if we succeed, it is better to go for a writ remedy that is economical. That is what my expertise says. Not because I wanted to say with the conflict of interest as such on the advocacy or the chartered accountancy. Both are being the persons who represent the law only. And in the interest of the SSC, we should take a call depending upon the facts of the case. In the small matters, we will not suggest to go for High Court. Then you follow better the route workout. But in case of when there has been high pitch assessment, when there has been a legal justice has to be given, in those cases, we should go for a writ which has been economical. That is my experiences.
What is the time when the judgment comes? In what time the judgment comes normally?
There is no time limit, but as such experience says it should be coming within a month or at the most 45 days. You get 45 to 50 days in the writ petitions to get the answer.
That's correct.
At least the interim, the stay.
At least you get the interim order, and your demand has been stayed completely.
Okay, I have given half an hour to ask the questions, so I finished my half an hour. Thank you very much.
So kind of you for giving questions which are not bouncers to all of us. Yeah. Thank
Okay,
you.
excellent
No,
question.
no.
Excellent questions, ma'am. Very useful for members who are not into litigation practice and value addition to the practice. Thank you very much. I now introduce Bhunesh Kankani, Advocate Bhunesh
Rajesh,
Kankani.
only 1 minute. 1 minute. I just wanted Sanket to throw light on 119 2B applications and that genuine hardship case, and then you should want to Bhunesh.
Yes, please, sir.
Or you can ask Bhunesh to work out also.
No, please, Sanket.
Right. So 119(2)(b) is the power of the board to, in genuine hardship cases, to give reliefs. So basically, there have been a number of cases whereby on due to reasons which are beyond the control of the assessee, there have been cases whereby, as chartered accountants, since they are saddled with so much of new provisions coming in, due to one of the, it's a human error, happens with everyone. The chartered accountant himself or his associate or his intern or likewise happen to commit a mistake. The eventuality of that mistake happens to be that an entire the return not being filed under 80 AC, the entire deduction under 80 IB is disallowed. Now, in such cases, 119(2)(b) was filed by one of my clients, on the basis of which the chartered accountant was going through a lot of mental stress. He had produced a medical certificate. His child was going through medication. His wife was pregnant, and they were living in a nuclear family. On the basis of these facts, the board would still not condone the delay, and it caused genuine hardship to the petitioner, to the assessee. The Bombay High Court categorically came across heavily upon the board, stating that no routine order should be made. Every case needs to be looked into properly, and if there is a case of genuine hardship, they can provide all sort of reliefs, be it condoning the delay, allowing a deduction, or any other provision by a special or a general order. So one more thing that chartered accountants need to use now much more is 192. Yes, thank you so much.
Yes.
Thank you.
Yes, Rajesh. Over now.
Yeah.
Over to you.
Thanks a lot, sir. I request participants to please post your queries in the box. We will take queries after having discussion with Bhunesh Kankani. So if you have any queries, I think maximum queries we have already covered, sir. Still there is any scope of queries. So I request participants to please post your queries. I like to
In chat, someone asked how to ask the question.
it is on the box when they are.
When someone asks the question, how to ask the question. So you answer.
It is there only. Their box is reflected on video before below the video. They can put their question and raise. Yeah, I am introducing Bhunesh Kankani. Advocate Bhunesh Kankani is a fellow chartered accountant and also an advocate. His core area of practice is income tax litigation and advisory. He represents income tax matters before different courts and appellate tribunal. He is certificate holder in international taxation, which was conducted by ICI. He used to practice earlier as a chartered accountant, having firm name Bhunesh Kankani and Associate. He has recently co-authored 2 publications of ICI. One is registrations of charitable and religious institutions for income tax exemption, technical guide on income tax on reconstitution of firm. Both publications are very useful for members and very good feedback from the members. We was also a member of Direct Tax, International Taxation and FEMA Committee of WRC of ICI. He keeps writing articles on various forums on income tax, including Pune chapter of WRC of ICI and Tax Guru. Even his articles can be read at bhuneshkankani.com. He is also part of social organization working towards national cause. Thank you, Bhunesh, for joining this webinar. I request you to please add to this session.
Yeah. Dhanyavad Rajesh ji for introducing me. I hope my voice is audible to everyone. Am I audible, Rajesh ji?
Yes, you are audible.
Yeah. So As thanked Rajesh for giving my introduction. I am grateful to Chitle sir, who is always on the front foot for the fraternity members, arranging various different seminars. And this seminar with webinar, particularly with regard to RITs, in the contextual scenario is of very much importance, because I remember that recently even in finance bill 2024, which has been enacted, they have reduced the timeline for reopening the cases from 1st September 2024. Why I'm highlighting this, my friends, is 1st September is yet to come. We are in August. I have been informed that department is in full-fledged motion to reopen cases which could not be reopened after 1st September, the 6th year. Because in this budget, they have reduced the timeline from 10, 6 to 5 now. So it is very interesting, and the time is such a that we need to know why and how to proceed with writ petitions for the very different aspects, very reason that there are situations where the assessing officer is ultra vires many procedural aspects, his jurisdiction, and the very basic aspect, whether faceless hai ho or jurisdictional hai ho, it is across discussed. It is discussed across in every corner of department कि हम केस तो खोल रहे, क्या टिकेगा नहीं टिकेगा भगवान जाने. But yes, we are here to discuss. We could very easily infer from the last 1 hour that writ is a prerogative power of the courts. Writ is a prerogative of the courts. It is discretion of the courts. So it is upon the advocate who present your case to seek the prerogative power in your favor and get certain orders in your client's favor. Friends, why are we discussing this aspect which an advocate practices in court with chartered accountants? We need to understand that very categorically. I am sure that I was not there in initial half hour, but I am sure Swaz sir and Chitle sir would have very properly illustrated on that CAs are the initiators. I also practiced as CA. Many times I faced that there should have been some remedy. I should have jumped directly to court and get the relief on that. So chartered accountants are the initiators. You are the point, you are the Gangotri of all the aspects. कहाँ पे क्या issue आएगा, you would be communicating those issues to your advocate, and they would be representing so that a better law emerges. The anomalies in the practices, anomalies in the procedures are done away. Friends, the duty entrusted on me today is to deep dive into the writs, its natures, what are different kinds of writs. Yes, I had heard Sanket had thrown light on all these aspects. He brushed away on many aspects, that how, what are the timelines, how the court look at upon whether a delayed writ petition could be entertained or not. So basically, friends, what is a writ? To put it in very simple language, it is a formal written order of a court. It is that simple. It is a formal written order of a court or a judge. So in our country, writ emanates from Indian Constitution, Article 32 and Article 226. Article 32 empowers Honorable Supreme Court, the apex court, to issue direction orders or writs, those 5 types of writs which has already been mentioned. And Article 226 empowers high courts. So generally, what people think, why to approach high court when we have Supreme Court, who is the apex body? Ultimately, we are required to, if High Court doesn't allow you, you will be required to go to Supreme Court. This is a general mentality, so direct Supreme Court jate. So friends, what needs to be understood here is the writ powers of High Court is much more than Supreme Court. The reason here is the article number 32 of Indian Constitution empowers Supreme Court to issue writs in cases of fundamental rights coming into the part 3 of the Constitution. Be mindful of this. Part 3 only. Part 3 is with regard to your fundamental rights. Whereas Article 226 In addition to the fundamental rights under Part 3, other purposes, other issues can also be covered under the writs before Honorable High Court. So that is the reason why High Courts have huge ambit of writs. So friends, recently you would have come across that 43BH issue. We had heard that the matter was taken by Federation of Trade and Vyapar Mandal, I'm not remembering the exact name, to directly to Supreme Court. Ultimately, that petition was withdrawn and the leave was sought that the petition be filed before respective High Court. So this is what I'm trying to highlight, that we should not directly jump to Supreme Court, but we should go to High Court because they have a much wide power than Supreme Court. Ultimately, it goes without saying that the law laid down by apex court is law of the nation, law of the land, and the petitions adjudicated by the respective High Court are governing those respective territorial jurisdictions. We'll come upon the jurisprudential value of High Courts in later part of our today's discussion. So basically, friends, as Sanket has already highlighted that there are 5 different types of writs: habeas corpus, mandamus, prohibitio, and quo warranto, and certiorari. Friends, I'm here to discuss or deep dive into these different natures, 5 different natures of writs. What is habeas corpus? So the literal meaning of habeas corpus is to have the body of. This type of writ is generally issued when an unlawful detention, what I mentioned, unlawful detention has occurred to enforce the fundamental right of individual liberty. So what needs to be emphasized is the detention is unlawful. And the writ is issued to a person who has arrested that another person who has filed the writ. So friends, the apparent question is, if a person is detained, how can he file the writ? So in this particular scenario, another person, a family member, can also file an application, or a stranger can also file an application in public interest in such scenario. Generally, this kind of writ is only used in tax matters when an assessee is being continuously called for and he has been detained there. He's not been allowed to go outside for 1 day, 2 days, 3 days. So that is where the writ of habeas corpus come into picture. The another important writ is mandamus. As Sanket rightly mentioned that we generally use writ of mandamus, prohibition, and certiorari in the tax matters because mandamus is, the literal meaning of mandamus is to command, to give command, we command. So this type of writ is used when a public official or a public body or a corporation rather, who is subordinate to court, is required to do some duty, but he has failed to do that duty. So after this writ is issued, the respective official needs to resume that work. He needs to execute that work. He needs to do that duty which he was not doing that. So generally, what are the grounds of writ of mandamus? Petitioner must have a right recognized by law. Unless he has a right which is recognized by law, he cannot use this writ of mandamus. And there should be infringement of his right. There should be infringement of right, and petitioner must demand the authority to perform the duty, and there should be no other remedy available. We will be discussing on this alternate remedy also in depth in my next course of discussion. And the crux is that official has not performed his duty. So to put it in very simple language, layman language, this writ can be enforced by the courts when the officer who is casted with the duty to perform some acts, he's sitting on that file. Basically, for his inaction. So, for example, you have filed a high-pitch assessment complaint, but there is no disposal of it. You can file a writ petition that it should be disposed. You have filed a request for issuance of refund, but they are sitting on your file and refund is not issued. In that case, a writ of mandamus can be filed, because you are asking the court, you are requesting the court to issue a direction or order in nature of mandamus, that that particular officer be asked to do his duty with regard to issuance of refund or staying the demands, whatever it may be. So there cannot be any exhaustive list in any law कि mandamus कब use होगा, prohibition कब use होगा. Yes, but there are some indicative situations where we can see that this kind of writ is generally used over there. That is why I initially mentioned that chartered accountants are the initiators. You may bring some situation that ये हो गया है, and then upon discussion we may come upon a conclusion that for this particular purpose, for this particular aspect, a writ should be filed, and which particular writ has to be filed. Now moving ahead, my friends, the another kind of writ is prohibition. As the word itself suggests, it is to prohibit the authority, to forbid the authority. This type of writ is used when a court means or an authority lower to the high court exceeds its jurisdiction, which is not possessed by him. So the point here is, which needs to be mindful of, that the lower authority or the lower court has overstepped its jurisdiction, or the court has gone against the law, the lower authority, lower court. So basically, proceeding must be pending before that lower authority. When you are going in high courts with regard to this writ of prohibition, the proceeding should be pending before. To give a ready example in this situation is, there is a 148A clause B notice, then there is a 148A clause D order along with 148 notice. You have, and accordingly, as you know, in 148 notice, there's a timeline to file ITR. And you wish, I'm giving a very routine daily life example for all the chartered accountants, because everybody would be having this case in their office. And you have challenged that notice, order, and the notice under 148. So while filing that writ petition, one of the nature of writ which you would be seeking is of writ of prohibition, so that the authorities doesn't proceed with the case. They don't go ahead with the proceeding, because after issuance of 148, generally they give a 3-month period or 90 days time. There is no such provision in the act in the erstwhile. Now they have amended and they have stated that within specified period it is not filed, then it will be considered as written not filed under 139(1). So it's an important aspect, because the moment you don't file ITR, the chances that your case is completed under 144 increases. So that is why you need to approach court and say that proceeding be stayed. That is, the officer be prohibited from proceeding ahead. This is how a writ of prohibition works. The another writ, nature of writ, which is another important kind of writ, is certiorari. So the literal meaning is to certify or to be informed. This writ is issued on the basis that there is some excess of the jurisdiction which an officer has enforced, or there is a lack of jurisdiction or error of law is there. Means officer was not having jurisdiction to proceed with the case, or even after having some jurisdiction, limited jurisdiction, he has proceeded with some extra powers. Or another point I can highlight is the officer of Calcutta, for example, who has a territorial jurisdiction of his range, has initiated a case, say for example, of assessee sitting in Gujarat, in any city, Ahmedabad. So in that case also, he is exceeding his jurisdiction. So this writ of certiorari is to be enforced at that moment of time. So the grounds of enforcing this writ is that the officer has overstepped his jurisdiction or abused his jurisdiction. So these two parts, overstepping or abuse of the power, should be present. And another aspect or another reason where this writ could be used is a violation of principle of natural justice. This is another important aspect. To give a live example is, which has very frequently happened in last 2 years, is that in the proceeding of 148A proceeding, a notice under 148A clause B is issued, and a typical time limit of 7 days is given. On 6th day, you go to officer through e-filing portal, and you say that I want some extension of time to file reply. And the officer, without whispering anything on your adjournment, passes 148 AD order. So this is a classic case where your principle of natural justice is not followed. So this is a case where writ of certiorari can be enforced through courts, and the matter can be brought again back to the file of AO. So friends, this is another aspect, another important writ. I will move ahead, and the another kind of writ is quo warranto. So what do you mean by this? Quo warranto is the literal meaning here is by what authority or warrant. By this writ, you ask the respondent authority to show his jurisdiction, or to ask whether the public office which you are holding, whether are you holding it rightly or not. So after this writ is issued, the legality of claim of person's office is inquired. Means the office which he is sitting upon, whether he is legally sitting there or not, to put it in very simple language. So the condition where this kind of writ can be enforced is the officer has wrongfully assumed the office. I need to highlight that this writ cannot be enforced against a private person or a private office. And this office has been created by constitution or out of state duties. So, friends, as I have highlighted different types of writs, and I would like to now take some real situation, the life situation where how this procedure or what kind these different kinds of writs are used. As while mentioning different kinds of writ, I have already given you example of 148A. I will simply continue that example. So I will just reiterate. Notice under 148A clause B is issued. Thereafter, you filed reply. 148A clause D order is passed. Notice under 148D is passed. Accordingly, notice under order under 148D is passed, and notice under 148 is issued. So friends, I am highlighting this scenario before you to just highlight how all these recent rulings of High Court, Supreme Court, you would all be aware of Union of India versus Ashish Agarwal. So I'm just highlighting this to make you aware how the proceedings or how we should take up the case ahead. So in this scenario, three kind of writs would be apparently enforced. First is writ of certiorari, second is writ of prohibition, and writ of mandamus. Why these three? For the writ of certiorari is for the reason that officer lacks jurisdiction. Say for example, the notice is issued by jurisdictional AO as on the date of the ruling of various different high courts is considered. The notice is issued by faceless, no, not by faceless AO, but by jurisdictional AO. Or the notice under 148 is issued after the time barring, that is after 6 years. As we know, section 149 subsection, the proviso of section 149(1) talks about, and the proviso 4, 5, and 6, whether they are applicable or not, this has been discussed at length at different courts. So for challenging those jurisdiction issue, you need to highlight or mention the writ of certiorari. Writ of prohibition comes into picture for the reason that you, since you have filed the petition, and as the question was also asked by Rekha Dhamankar ma'am, that whether during the pendency of a writ petition, can officer proceed with the case? Her question was with regard to another assessment proceeding, but I would take into that question into a such manner that can officer continue the proceeding even during the pendency? So in that case, you need to take an interim stay order from the court. For that, you need to point out that you are also seeking or the writ of prohibition in your writ petition. And another is writ of mandamus. So for example, in that example, the officer who is required to give you the material along with your notice under 148A clause B. But as usual, he has not given any material. So you may also ask the court to direct the officer to give those copies of documents or material, evidences, books of accounts, as mentioned in under 149(1)(b) to the assessee, to the petitioner, for which writ of mandamus is to be enforced. So friends, this is a case of one reassessment. Writ of prohibition, I'm just trying to give you another scenario. There's a search proceeding going on you, and you means your assessee, you have a feeling that there is no reason to believe why there is a search. So you may knock the door of courts by using the writ of prohibition and ask the respective authorities to bring the case record before the honorable court and let the honorable court read the reasons to believe recorded by them. And by this, you may stop the proceedings, search proceedings. That is where writ of prohibition comes into picture. So, dwelling on another issue, I will just move ahead. Whether there is a time limit given for filing any writ petition. So, it is a point which has already been discussed. I will just dive deeply into this aspect. Friends, whenever we talk of time limit, the Limitation Act has to come into picture. So, whether filing of writ petition is also covered by that Limitation Act, the answer is no. Even Limitation Act doesn't restrict or provide any timeline for filing any writ petition. And at various different situations, courts have held that there has to be some reasonable time. The court follow their own procedures, as rightly mentioned by my friend Sanket. So, what is reasonable? So, I had read a judgment wherein courts have said that it will be unreasonable if we give what is the reasonableness. It will be unreasonable to give what is the definition of reasonableness, because reasonable is subjective. What may be reasonable for one case may not be reasonable for another case. So what is to be highlighted is there has to be some, if there is a delay, for example, if there is some delay, you have to provide the cause, the reasonable cause why there is a delay. If you could succeed on satisfying honorable court that the delay was because of XYZ reasons, then honorable court, as I mentioned at initial stage, it's a prerogative power of the court. The court may use their discretion in your favor, and they may accept your or admit your petition also. So friends, when we talk of alternate remedy, that you have the alternate remedy to go to CITA, then why to knock the door of High Court? See, the principle here is when you have any effective or efficacious alternate remedy available, generally courts doesn't entertain such writ petition. However, what needs to be noted here is in the cases of assessments, particularly in tax cases, as you know, against the assessment order, as the topic of today's discussion is also writ remedy for assessment. After assessment order is passed, you go to CITA. Against CITA, you go to ITAT. So this is whether this is an efficacious or effective remedy is another practical point to ponder upon, because from last 4 years, the CIT appeals are very reluctantly the cases which are disposed are very less. So without delving into that aspect, whether that is effective or efficacious, I would come upon the principles laid down by the courts. The courts say that even if there is some effective or efficacious remedy available, but in cases where the fundamental right, the matter is for enforcement of fundamental right, or there is some violation of principle of natural justice, or the order is passed, the notice is issued without any jurisdiction, or any wires of law are challenged. In these 4 scenarios, even if there is some effective or efficacious remedy available, alternate remedy available, even in those cases, writ petitions are admitted. Writ petitions are admitted. Why I have highlighted these 4 particular aspects before you, my friends? For the very reason that what generally we understand, अरे भाई assessment order pass हो गया है, we can only go to CITA. We cannot go to High Court. Friends, when a order is passed and you feel that the order is without jurisdiction, or your natural right, which is of being heard, is not adhered, or there is some fundamental right being breached, in those particular scenarios, you need to directly approach High Court, because these issues may not be discussed at CIT level. And as rightly highlighted, mentioned by Suhas sir, what we need to consider is time and cost. Since last 4 years, CIT appeal is not disposing your appeals. ITAT, again, since because there is few disposal, ITAT is disposing cases, but what needs to be seen is on what grounds. Those cases with CIT appeal, in all those cases where CIT appeal has not heard you or not dwelled into all of your submissions, ITAT is remanding the matter back to file of CIT. So what is that? You are just going round and round and round. So in all those particular cases where you feel that this will happen at a later stage, it is better to approach High Court. It is better to approach at High Court at this nascent stage. See friends, 148A clause D order is not an appealable order. It is not an appealable order. So if you think that there is some if you think there is some non-jurisdictional aspect involved in that 148 AD order, the opportunity of being heard is not given. So it is better to directly approach High Court, because if you point out this aspect before your faceless officer during the course of assessment proceeding, a stereotype line is given to you that we are ready to give you fresh opportunity now. But what needs to be seen here is that proceeding for initiating your case, for initiating 148 notice or issuing 148 notice is a separate proceeding in the existing scenario. It is a separate proceeding. So at that moment of time, you need to think. Another point which I would like to highlight before you all, can all cases be taken to High Court irrespective of the time zone you are sitting in? By mentioning time zone, I would like to highlight is, say for example, your case is reopened immediately after 2 years, and if you wish to go to High Court, High Court may rule in your favor, but still the department has 1 year left with them. So what needs to be strategized is the situation in which your case stands. The situation in which your case stands. If the same case on different footing could be reopened within the next 1 year, so you need to think upon whether it is the right time to approach High Court or not. Because ultimately, we as a chartered accountant fraternity are more interested in the ultimate benefit of our clients and with the interest that litigation comes to end. So we need to strategize the time when you need to approach to the High Court. Friends, coming upon the jurisprudential value of the writ petitions. Friends, as we all know that writ petition is emanating from your fundamental rights, your individual fundamental right. So for determining whether a writ petition has a jurisprudential value or not, what needs to be first understood is the terminologies, or the thing is, the judgment is judgment in personam or judgment in rem. What I mentioned, judgment in personam or judgment in rem. What does it mean? Judgment in rem refer to an order against a thing or status. Judgment in rem is basically a judgment against the world. Against the world. It is against a thing or status, and whereby said judgment would be where that said judgment in kind of rem would be binding on other people is only when that status or thing is affecting that different person. To put it in a simple words, if a judgment is passed on a point of law, to take a ready example, Hexaway Technologies, Honorable Bombay High Court passed the judgment highlighting that order passed by, or the notice issued under 148A clause B and order under 148AD and notice under 148 by jurisdictional AO is not as per provisions of 151A read with 144B. So that judgment is with regard to the status, that whether that jurisdictional AO can pass the order. So in that scenario, such order should have a jurisprudential value. Whereas there is a writ petition with regard to certain circumstantial facts between you and your officer, whether that particular judgment can be used as a jurisprudence across all the officers, that is a matter of fact, or matter of fact for the reason we need to see that judgment on what particular aspect that has been passed. So friends, I would take you to the another part, that what is the power of court? Can they struck down any law, any legislation, or any subordinate legislation or rules? Friends, it goes without saying that any law has to be in sync with the fundamental rights. If any law is not in sync with the fundamental rights, then it is open for the court to struck that particular law. So there can be, before moving ahead, I like to highlight that law is being enacted by the parliament. So parliament has all right to re-enact that law from another fashion. I am not mentioning that since parliament has a right to enact that law in another fashion, we should not challenge that law, but we should challenge that particular infringing law so that a better law is emanated. Friends, recently you would have come across various situations, particularly with regard to charitable trusts, that there were a lot of circulars, and one of the circular was so discriminatory that, if you all know with regard to the registration procedure, that circular, if I'm not wrong, circular number 6 of 2023, it allowed it extended a time with regard to 12 AB, but it did not allow the extended time to ATG application. So the matter went to High Court, but to be more precise, Honorable Madras High Court, in case of Narsimha Priya Charitable Trust, Honorable High Court held that that particular circular is discriminatory. The argument which was given from the revenue side that under Article 14, the prohibition is with regard to only class legislation. There is no prohibition with regard to reasonable classification. The Honorable Court saw that there was no reason given by the revenue that why ATG aspect is kept aside and other aspects have been extended. So on that very front, Honorable Madras High Court struck down that particular part of that circular and allowed the application, the delayed application, to be entertained by the respective commissioner. Friends, there are different scenarios in all laws where writ petitions could be filed. I would like to just throw light upon certain situation under the Income Tax Act where you could approach High Court for seeking relief. Certain situation which I have come across is refund. So why refund aspect can be approached to High Court? Because of inaction. The authority who is casted upon with the duty to issue the refunds is not acting. He's just sitting on the file. For his inaction, you can file writ of mandamus. That, sir, this is my case. There has already been such a huge delay. I've continuously been approaching that respective officer to give me refund, but he's not giving. So that could be one of the reason. Stay petitions. So the general procedure which we follow, as it is given by the CBDT, is first, and as per section 220 subsection 6, first you need to file stay petition before your AO. AO may accept or reject, and if it is rejected, you can file a review petition before your Commissioner Income Tax. Even if Commissioner Income Tax doesn't grant you stay, because there are certain principles given by different courts what that CIT has to follow. If he is not following those principles and stay is rejected, in those scenarios, you can approach High Court. Many times what happens, my friends, the tax demand is such huge that your entire business can come to a halt. You may bring this aspect to the knowledge of respective court and say, if that stay is not given, my entire business can come to an end, which is again a very important aspect from the fundamental rights point of view. Another is condonation matters. So Sanket has already highlighted how a condonation case can be taken before High Court. I would like to just highlight what is genuine hardship with regard to refunds, with regard to filing a delayed ITR, because there is a circular of 2015, and if I'm not wrong, last year in June or July 2023, that circular was again refurbished and the limits were enhanced with regard to power of CIT, CCIT. So generally, the tax authorities don't allow you to file a delayed ITR using that condonation circular stating that there was no genuine hardship. What is the genuine hardship which has been caused to you if you don't file that ITR, or what was the genuine hardship owing to which you could not file your ITR within time? So honorable courts have held that not getting refund, not getting the due money back in the hands of assessee is also genuine hardship. So this is what I wanted to highlight with regard to seeking condonation. So another situation where you can go in income tax matters is your search proceeding. I have already highlighted on it certain orders and notices which are against the principle of your natural justice beyond jurisdiction. The interesting point which I think very rarely has been uh, considered for filing writ is the issuance of lower tax deduction certificates under section 197. It is mostly in cases of cooperative society because of that ATP dispute where the authorities have not been granting the certificate stating that we have so and so judgment, though that is not applicable. That is another story to be discussed at different time. They are not issuing 197 certificate, owing to which cooperative societies are really suffering. So we need to explore that kind of rejection order, those kind of rejection order before courts. Another aspect, another issues wherein you can explore the writ forum is transfer of cases under section 127. When a case is transferred from one jurisdiction to another, and many times it is seen that you have not been given the opportunity of being heard. So in that case, you can directly challenge that action before honorable court and say that if I would have been heard, probably that case would not have been transferred. And another aspect which Sanket has already highlighted, that 254 MA application, because it is not appealable, you can directly challenge in writ petitions. So friends, the point which I wanted to highlight before you all in today's brief discussion is the writ powers are discretionary, prerogative, though those powers are discretionary and prerogative, courts have always held that the fundamental rights, and particularly 19(1)(g), that is the right of doing business, should not be impeached, should not be infringed. And courts have many times held in favor of assessees that wherever an officer who has exceeded his jurisdiction, who has no power on that case, they have struck down those cases, they have quashed those cases. So friends, that is all from my side with regard to writ petitions, different nature of writ petitions. If any other questions are there, I'm open, I'm here to discuss with you all. Over to Rajesh sir.
Thank you. Thanks a lot, Bhunesh. Excellent deliberation. You have covered almost aspects for the participants. I don't think there are any queries. Let me check. Is there any queries? Two queries we have received. One we have already discussed. That is, what is the normal range of fees charged by lawyers in case of filing of writ?
On facts and circumstances of the case.
Yes, sir, it is a very important point to be discussed. Though sir has already highlighted, many cases don't come to High Court just because एक मन में दड़पन होती है. To put it in a very simple language, that if I take this matter to High Court, the cost will be huge. See, we as a chartered accountant in our very educational stage also have studied the cost benefit analysis. We need to dwell upon that. We need to see what is the benefit and what is the cost in front of that, considering the time, the interest, the harassment, the various hardships. Because the moment a assessment order is passed, the recovery officer is behind you. We need to think from that angle. कि मेरे को क्या फायदा?
Also, there is a mindset कि court need 10 years, 5 years, 15 years time to give the
Generally,
decision.
that is in appeal, as rightly mentioned by Suhas sir and Sanket. That, see, I would like to go upon the basics. Why is writ remedy available? Because of your fundamental rights. If courts take 5 years, 10 years, because your fundamental rights are infringed, there is no point. There have been times where there were such huge delays, but recently, see, it is all upon advocate. They can always mention the urgency before honorable bench that this is the pressing issue which needs to be discussed at the earliest. So that thought process that ki 10 saal lagega, 12 saal lagega, yes, it is there for appeals. We are on the point of writ. So it generally doesn't exist on given date.
Sir, you
So
want to
again, you can highlight something about what happens that in case of appeal decision, there is a precedence value for writ, there is limited precedence value. Maybe High Court will follow, but it cannot be cited as a decision. So on that aspect, if you can talk.
Sir, as I took certain time of my today's webinar on with regard to the jurisprudential value of High Court's writ petition, writ order. As I had mentioned there that what we need to see is judgment in rem and judgment in persona. If out of that writ petition, a law is laid down, kind of a point of law is discussed, as I mentioned that case of Hexaware, if I mention the case of Siemens, wherein the point of law was discussed, when the point of law was discussed, so it carries some jurisprudential value. See, what needs to be understood here is how to enforce the binding precedents. Generally, binding precedents can be enforced when we highlight that if you don't follow this judicial discipline, there will be contempt of court. There will be contempt of court. The officer should be made aware that if you don't follow this jurisprudence, there will be contempt of court. So when can be there a contempt of court? My friends, we need to understand the difference between appeal order and a writ order. Generally, an appeal order carries jurisprudential value, and writ order, as an appeal order carries that value, doesn't carry. But when, as I mentioned, if that writ order is with regard to some point of law, it carries a reference value. We can always use that. A writ order of one high court can be referred by another high court, and another high court has its own jurisdiction. So they can put some time on again rediscussing it. So it is not that one high court order is binding on another high court.
See, there is one more question. I will take benefit of your presence and Suhas and Sanket. See what happens earlier in physical hearing era, assessees never used to take a plea or the ground of appeal that cost should be reimbursed or cost should be awarded if there is blatantly incorrect decision, some judgment is not followed. So now, not on writ, but if filing appeal before the CIT appeals or ITIT, should assessee take this particular stand that cost should be reimbursed, because if, like Suhas said earlier, that in your AIR some different information comes, so unnecessarily I am put to cost, prefer appeal and those things. That is not my default. So in such circumstances, I take a plea that cost should be awarded. What is the take on this particular contention?
Sir, before Suhas sir elaborates on it, I would just like to highlight, because I have taken these grounds in my few cases before Honorable ITAT. The situation where I have taken this stance is that I had sought an opportunity of virtual conference. I had sought an opportunity of virtual conference. CIT didn't allow me. What happened, sir? Because of this particular ground, ITAT remands that matter back to CITA, that you grant a virtual conference opportunity. Just because of that, the assessee's cost with regard to filing of appeal before ITAT, cost of advocate or counsel is also incurred. And what happens? He is again at square one. So that is the one issue. But another interesting aspect which we need to discuss here is cost to be imposed on whom. As you mentioned that there is some information in AIR, but AO has not seen. I have filed some submission, AO has not seen. In ITAT, I am against the order of CITA, whereas the mistake has been committed by the AO. Can ITAT impose cost on AO in a case against CITA? That is again a point to be discussed here, because impugned order is of CIT under 250.
No, even if order is against CIT appeals, ultimately the department represents. It is not the CIT appeal that represents. It is a commissioner represents.
I'm just highlighting this interesting aspect.
I understand.
Bhunesh, I understand what you say, but if you say the powers of the CIT appeal, powers of the CIT appeal are as good as co-terminus powers of the AO.
Exactly.
So if AO fails in his duty, CIT appeal has to recognize it, and he cannot just make the ignorance of the law saying that he has not done it. In that case, the cost has to be levied on that. And Shekhar, you rightly said, in such type of cases, we must raise the issue of the ground of the cost. Judge may not take it also, or may not award it also. But at least for the sake of taking those grounds, so naturally department will be cautioned. They will not take it very easy of making such type of, because right now there is no accountability on them. Accountability only on the assessee is there. So how accountability can be worked out? This is why in such type of cases, we should raise the ground for the cost to be awarded. At least,
because if
at least to the extent of piling of
appeals are
fees.
filed,
Sir, in general,
no, if 1,000 appeals are filed and everybody takes this down, say 900, at least there will be pressure on department to
Yes.
not to pass waiver orders.
And just for the information of the participant, income tax appellate rules has a separate rule for it, rule number 32A for awarding the costs. So we can include such grounds in our appeals before ITAT. Rule number 32A.
Yes.
Yes, please.
Bhunesh, can we say approximate cost will be 3 lakhs to 5 lakhs for one writ?
No, we cannot say a blank. There cannot be a blanket
No,
answer.
don't go on cost. That is not the aspect for discussion. Don't go on cost. That depends on facts and circumstances of case. If you have 10,000 rupees demand, don't go for it. If it is 10 lakh, you consider. So don't go on cost. How one can say cost?
Yes, anything else for me, Rajesh sir?
Yeah, anything else? Come on, chat box.
No, Shekhar.
Okay. Okay, anyone, Rajesh, Rekha, if you want to ask any supplementary question, otherwise we'll conclude.
Yes. I believe Rajesh has gone. Late
Rajesh
coming
is
probably.
So let us close. Rajesh or Rekha, you can propose vote of thanks and we'll close. It is well-deserved vote of thanks. Thank you, Sanket, Bhunesh, Suhas, for joining.
Thank you.
So-
Thank you, Shekhar. Thank you for giving opportunity.
Yeah, Rekha or
Yeah.
Rakesh, you can perform the
Yeah.
presentation.
Hello.
Yes.
Thank you, sir. Thank you very much.
Sir, one
Thank
last
you.
question is there. One last question is there to the panelists. Which type of cases should be presented before Supreme Court and not before High Court?
May I take
Bhunesh.
this question, sir?
Yeah.
Yeah. So as I mentioned that Supreme Court and High Court both have jurisdiction with regard to writ petition. Supreme Court have particular right with regard to fundamental rights. And naturally, our all writ petitions with regard to 19 is coming out of that part 3. Supreme Court, as a matter of practice, states that have you exhausted the remedy of writ before High Court? There is no exhaustive list. We cannot say that only these cases can be taken before Supreme Court. There is no exhaustive list. But as a matter of practice, Supreme Court ensures that before you climb the second step, you should have exhausted or climbed the step of High Court. And then, if High Court doesn't rule in your favor, you can file a SLP, that is an appeal to Supreme Court against that petition.
So generally, High Court has got wider powers in case of writ rather than Supreme Court.
Yes.
Yes. Thank you.
Thank you.
Just to conclude, I am just proposing vote of thanks on behalf of the committee. On behalf of committee and all the panelists, I extend thanks to all the speakers of the session, our moderator Rekha Madam, committee, all the committee members, all the participants and technical team for your all support.
So I think it is due for faculty, Suhas Bora, Sanket Bora and Bhunesh
Thank you so
Kampani
much,
who
sir.
have
Thank you so much.
really
Shekhar, I said
made
it right
session
now in
very
the
lively.
beginning also. It is our past chairman's club here today. So it's been our duty to only thing for me, it's been additional faculty that I could listen Bhunesh also and I have opportunity to have sharing the platform with my son Sanket today. Well, Vishwas and the Shekhar, for information, Ullas was having this dream. I wanted to see Sanket and Suhas together. Unfortunately, Ullas is not there, but at least you are there to work. Yes, Shekhar. Chalo.
Chalo, bye.
Thank you, sir.
Good night.
Thanks a
Thank you
lot.
so much. Thank you. Thank you so
Thank you,
much.
everyone.
Thank you, everyone.
And we will come out with publication on this particular issue very soon. The
Yes,
committee has already
shortly.
approved.
Yes, yeah.
There
sure,
are some
sure.
updations. After that, we'll publish it.
Absolutely.
Yeah.
Thank you.
Dhanyawad.
Yes.
Thank you.